Welcome back to Spokane Talks Live, and my guest is Ryan McNeice with that McNeice Wheeler firm.
That's right.
You would be one of the owners, wouldn't you?
I am.
Yeah.
I am, but we're very fortunate. We have several attorneys in our office that are coming from a diversity of different practice areas. So
Right.
we've been fortunate to have
You
Robin
have-
on the show. Talks a lot about employment law.
We've had to put up with Tom.
Tom Schrum, he's our resident patent intellectual property guy,
Right.
and he does just a fantastic job.
And he keeps talking about that, and I think over and over again, so that maybe at some point I'll figure it out and learn it.
He's a fun guy to
Yeah, he
chat
is.
with.
He
Really,
is.
I know last week you guys chat about merchandising and licensing in the
Right.
NFL, which is an interesting hot topic.
It is.
He's out of town today, actually. He left a little early to celebrate with family down in Oregon.
Ah, okay. Yeah, because it's his day, Turkey Day.
That's right.
Yeah. So I just had to make that clear.
And I think today we're going to chat a little bit about non-compete agreements.
Yeah, and what do you mean by that?
Well,
Explain what that is.
We see it a lot in our office, and me specifically. I do a lot
Okay.
of business litigation.
Okay.
And that involves a lot of employment agreements, whether that be memorandum of understandings, that be
Yes.
purchase and sale agreements, but a good old employment agreement, whether that be with you oftentimes see it in the professional services, whether it be accounting, whether it be insurance,
Right.
stockbrokers, financial advisors, as well as landscaping companies, et cetera. And why? Usually because there's a sales component involved.
Yes.
And when there becomes a sales component involved, the employer generally has put forth quite a bit of resources
Right.
to either train the
And support.
salesperson as well as overall marketing. So oftentimes in these employment agreements, they'll have specific paragraphs saying if you should leave your current employment
Right.
for a period of, for instance, a reasonable time frame would be 3 to 5 years, that you cannot solicit businesses like the one you're currently
Or
employed
take
with.
items that you've developed
That's
on
right.
behalf of the company.
So there really is a sense of fairness there.
Sure.
And oftentimes the first question that we're asked, either from the employee that's leaving or the employer, is, are these enforceable? Whether the contract's signed or not, are they
okay.
actually enforceable? And in the state of Washington, they are.
Okay.
But there are some caveats there.
Okay.
Again, as I said a little bit ago, there's the 3 to 5 year term. You start getting out there in the 6, 7, 8 years, it really
It's
is
hard
not
to enforce, I
It's
would
not
think.
going to be enforceable because there's a balancing act with the courts as to the ability to protect the employer's resources for having spent the resources versus folks' right to work.
Well, yeah, that's right. That's what I was going to say.
Yeah, I mean, if they leave a particular employment, whether it's a landscaping business or a financial advisor, if that is in fact what their trade is, we can't limit that too much. So balancing act, right?
Well, and a good example that I think most people can understand is if you're an anchor or a major reporter on a local station, you cannot work for a competitor in the Spokane market for 6 months.
And there's limited options.
Yeah.
I mean, there's not 100.
Right. Well,
Right?
and then, but where do you go if you're going to leave station A and go to station B?
Right.
How long really is that fair?
That's right.
That you would have to wait a year and go without salary or whatever
Yep.
it may
And
be.
whether there be a time limitation, as you said, a
Right.
year or 2 or 6 months, the geographic issue usually standard would be a 50 to 100 mile radius.
Right.
Okay. Well,
Right.
to your point,
Where's
where are you gonna
where's
go?
the local
It's-
TV person going to go?
It's got to be Seattle and or
Or
further,
Boise
obviously.
or Portland.
That's right.
Yeah.
So I think, Kent, you're really identifying the balancing act that a court needs to utilize
Right.
in making a proper decision. And we've litigated several of these, which really flesh out the importance of the provisions in the contract. Number one, probably stating the obvious, but having a contract.
Okay.
If this isn't in writing, it isn't enforceable.
Doesn't exist,
Yes,
in a
oral
sense.
contracts can be enforceable, but we've had issues where an employer
He
is
said, she said,
trying
kind
to
of thing.
enforce it and say, look, I didn't want this person to compete. That's really not going to stand up. Interestingly, the world I come from, in terms of the legal industry, there are not non-competes. So whether a law firm, small, medium, large, et cetera, they are in fact spending the same resources that
Right.
let me use an accountant as a
Right.
comparison. attorneys are probably spending the same type of marketing resources and
software, everything else that
Yeah.
goes, computers,
Yeah.
right?
In the accounting world, non-competes are definitely enforceable. And yet in the legal world, it's much like a physician, that you can't limit
Okay.
where a particular individual can seek.
I wonder who set that up.
Yeah,
Attorneys?
exactly. Yeah, exactly. So you have to wonder.
No, I don't really wonder. I can figure that one out.
Yeah,
Okay.
yeah, exactly. And that's why whenever we get these contracts, they seem to be getting bigger and bigger and bigger.
Oh, yeah.
I blame the lawyers.
Yeah.
So, and yet the
But
reality
you
is,
get paid by word.
well, I think they used to historically.
Really?
Yeah, and you know what? The reality of why these contracts, take a mortgage, for example, why they become larger and larger and larger, they don't need to be. A one-page promissory note, here's the piece of real estate I owe money
Right.
on, and I owe you, and I personally guarantee it. That literally is good enough for a court. The problem is then whether it's lead-based paint, whether it be this, whether it be that, and I'm not saying good or bad of those particular
Right.
documents, but what I'm saying is each of those items over time has been litigated, one more page.
Right.
Litigated, one
Yeah.
more page.
Well, they're just protecting your rear.
Exactly.
Yeah.
Exactly. So it depends on where you sit, I'm sure.
Where you sit,
Yeah.
protecting your rear. That was purposeful, wasn't it?
I have an uncanny ability to unfortunately do that.
Yeah, okay.
Whether it makes sense or not. But I think as I said, the validity of these contracts for non-competes is where we get the calls.
Okay.
And oftentimes the way the contracts should read, or at least the contracts that we create, damages are actually hard to ascertain.
Yes.
Why?
I can imagine.
Let's say we're both employed in an accounting firm and we both decide to leave that firm. But obviously the employer spent a lot of resources on us. So we leave. Let's say we are forbidden essentially by the contract from contacting our entire list of clients.
Right.
What if we go contact them? Does that mean that the accounting firm actually lost the client? Not necessarily, but we certainly have breached that contract,
Yeah.
at least by the
Because
verbiage.
ultimately it's up to the client out there
Right.
to make a decision.
Right, and that's a good point, Kent, because oftentimes what we'll be asked is, well, what if the person comes to me?
Yes.
I didn't reach out to them.
Right.
That's kind of a form over function scenario, because if the person does reach out to you, the right thing to do per contract is, unfortunately, I can't work with you. I can
okay.
certainly recommend somebody else or go back to the firm that
Right.
I came from. But that is a question we're asked quite a bit. And unfortunately, again, depending on where you sit, if you're the employer, you are, of course, protecting your resources
Sure.
and the book of clients, if
Right.
you will. On the other side, the employee, if they leave and they try to take those clients, if you will, because those damages are hard to prove, what you find in good non-compete agreements is what you call a liquidated damage clause.
Okay.
And because the damages are hard to say, well, I took that client. Well, I didn't take that. Well, they called me. No, I called them. Instead of that, what these contracts will say is if I am in breach of the contract, we are setting by our signatures right now 1.5 times commissions on those lost clients.
Okay. So you spell it out ahead of time.
Makes it easier for the courts.
Yeah, I would think so.
Yeah.
And probably almost go to arbitration at that point
Yep.
instead of courts.
Yeah,
because
absolutely.
It's pretty well spelled out. so-
Mediate, arbitration,
Right,
or
right.
court. But it really certainly is, when you talk business litigation, comes up all the
Yeah.
time.
Now, should somebody out there want to get in touch with you to talk, how would they do that?
Well, McNeiceWheeler.com. Yeah, we got tricky
Yeah.
on that one. Name McNeice Wheeler, so we went with McNeiceWheeler.com. However, interestingly, give a plug for Well Dressed Walrus,
Yes.
our design and web company that we work with. They said, Ryan, your name is too hard to spell. McNeice.
Right.
Why? It breaks the rule. Because my name is McNeice, and that breaks the rule. So they said, you need to get the domain name
For-
McNeice Wheeler spelled wrong.
Right.
And so I did that.
Yeah.
Because everybody spells
Well, you've
it
got
wrong.
several.
Yeah.
Yeah.
We do have several domain names. But they can reach us at 928-4141, and they can call any of our attorneys. We cross over.
Quit hitting the table.
They cross over in a lot of different areas. Like I said,
Yeah.
Allison does a lot of family law. Becky and I do a lot of business litigation, and Robin, a lot of employment law. Tom,
Right.
a lot of
Yeah,
patent.
you've got a good crew.
We really
you really
do.
do.
Well,
and they're a fun crew.
We do
because
have
I
fun.
give them a bad time when they come in, and they're, especially Tom, always
Yep.
willing to get back at me.
Yeah,
so
yeah.
that's important.
Well, we
'Cause
have a
wanna
lot
have
of
some fun here.
We do have fun. I think folks sometimes say, "Gosh, you guys look like you're having too much fun." But the truth of the matter is, the legal industry, like a lot of industries, it's stressful.
Yeah.
And so we do try to have fun when the opportunity is there.
Yeah, great. Thank you very much.
Thank you for
We're
having
going to
me.
take a quick break, and we'll be back with Don Morgan talking about something around investments, I'm guessing.
Thanks for
That's
having
his
me, Ken.
job. Thanks.
Appreciate it.
For the Inland Northwest most comprehensive sports report, think outside the